All right, good afternoon, everyone. James Pittman here with Docketwise, and this is the webinar on LGBTQ immigration issues up to 2021. And I'm here with my two guests. We have Randall Chamberlain, who's in Toronto. His practice is in New York City. And we have attorney Connie Kaplan in Fort Lauderdale, Florida. Before we get started, let me give each of them a moment to introduce themselves. Connie, do you want to go ahead?
Sure. So I'm immigration attorney Connie Kaplan. We help immigrants everywhere make the United States their permanent home. We do focus on LGBT family petitions or family-related petitions. And we are located in Fort Lauderdale, but that has not stopped us from having clients in 47 states and over 100 countries.
Wonderful. Randall, about yourself?
Thank you. Hi, I'm Randall Chamberlain. I have a solo practice in New York City, but like Connie, represent people from across the country and coming from around the world. My practice focuses primarily on family-based immigration, including marriage-based and lots of LGBT clients, and affirmative and defensive asylum cases. And most of my asylum cases, I'd say, are based on sexual orientation and gender identity.
And to each of our guests, is this a particular niche that you sought to get involved in consciously, or is it something that developed? How did that happen?
Well, in my case, it was really proximity. My office is very close to Wilton Manors, which is one of the most dense populations in the country of LGBTQ people who identify themselves as LGBTQ. And years and years ago, when we started practicing, we had a couple of cases, and then word spread around. I guess if you like, once you're in the community and they trust you, they feel comfortable.
Wonderful. Randall?
So I guess I am in the community. I'm a gay man, so it was a natural fit for to start my practice. I don't focus exclusively on LGBT cases, but I started out working for a firm that does a lot of them. I've done a lot of volunteer work with immigration equality and just sort of grew my practice organically that way.
Wonderful. Immigration Equality, certainly a wonderful organization, a premier organization on dealing with the LGBTQ immigration issues. I also, in years past, I was a cooperating attorney for them as well. Wonderful. Okay, let's get into the substance of our talk today. A few background notes. Historically speaking, looking back from 2021, how far we've come. I can remember when there were statewide and federal bans on same-sex marriage. That wasn't that many years ago. In June 2013, the landscape really began to shift federally. The Supreme Court of the United States in U.S. versus Windsor, the Supreme Court struck down the Defense of Marriage Act as a violation of the Fifth Amendment to the U.S. Constitution. That forced the federal government to recognize validly performed same-sex marriages and accord the federal benefits to married couples, which were connected to either the state of residence or the state in which the marriage was solemnized. That was followed in the immigration context by a statement from then Secretary of Homeland Security Napolitano when she directed USCIS to review immigration petitions filed on or behalf of a same-sex spouse and treat them in the same manner as those filed on behalf of an opposite-sex spouse. That followed shortly thereafter in 2013. And then the next bombshell was June 2015, a date I'm sure all of us remember, the Supreme Court ruling in the case of Obergefell versus Hodges that said that it affirmed the fundamental right under the U.S. Constitution of same-sex couples to marry on the same terms and conditions as opposite-sex couples with all of the accompanying rights and responsibility, and said or ruled that that right was guaranteed by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So those were two monumental cases which really paved the way for us to get to where we are today. There was a lot of progress during the Obama years. The Department of Homeland Security came out with guidance to refugee and asylum officers on adjudicating claims by LGBT refugees and applicants for asylum. USCIS in 2012 adopted a policy to clarify the eligibility of transgender individuals and their partners for family-based immigration benefits. 2012 also, President Obama allowed undocumented young persons to apply for deferred action, which helped a lot of undocumented LGBT youth to obtain temporary relief. And December 2012 was another important change when the DHS adopted regulations pursuant to the Prison Rape Elimination Act of 2003. That those regulations adopted by DHS brought the protections from that law to the immigration detention context, including measures aimed at addressing particular vulnerabilities of LGBT and trans individuals in immigration detention. All right, now I want to get into family-based immigration considerations for same-sex couples. So the first question we come to is, when you're applying for immigration benefits, is the marriage legally recognized in the place where it's performed? So sometimes same-sex marriage is recognized in a certain location, but not in the entire country. We would include places like Mexico under that. It's valid in some states, some locales, but not nationwide. And sometimes there's nationwide prohibitions, for example, in Pakistan. So let's talk about whether, so first of all, Connie, to yourself, what would you look for when you have a case of a same-sex marriage? What are sort of the guiding lights that you look for to determine whether this marriage can qualify for immigration benefits and whether any previous marriages were validly terminated?
So we do need to prove that the marriage is legally recognized, so there is a legal marriage, and then the second prong is that it's a bona fide marriage. So first we need to prove the legal part of it. So we need to make sure the marriage, the actual marriage between the parties, either the one that already occurred or the one that it's about to occur, for example, in cases of fiance visa, it's going to be legal or recognized. And any prior divorces that either one of the parties may have had were legal. So when we are talking about that, for example, the same-sex marriage is recognized as of right now in only 29 countries. So it really makes a difference where the foreign national is coming from. Certain, like you mentioned, in Mexico, there are certain states, even within a country, that accept it, but federally is not recognized. So when the couple intends to get married, let's say in the case of a fiance visa, first we need to make sure, and of course, Randall can correct me if I'm wrong, we need to make sure that where the intent to get married, it is legal, and that is going to also be recognized in the place of residence if someone is going to petition for that, for the foreign national. What I mean by that, and I can give an example, we had a client whose marriage was not recognized because he got married in one of those provinces in Mexico where it was recognized. However, subsequently, the marriage was not recognized in the United States. Then the law changed and it became different. So that made a big difference. We also have issues where same-sex couples cannot have a legal marriage, but they are engaged in some other type of union. And we are not yet to talk about civil union and civil partnerships. For example, it could be a tribal marriage, or it could be one of those other that may be legal there, but unless it is legal for immigration purposes, it will not count. So tribal or religious marriages, we are always look out for. If there was a prior divorce, and this is a biggie for where we are, and I'll go into it for a second, especially with Randall being in Canada, I'm just saying. Seriously, we are in Florida, so we get all the people coming to Florida. In Canada, if you get divorced, there is a waiting period until your divorce actually becomes final. And most people are not advised of that, or they really just don't know. And they come here and they get married before the prior divorce is final. Or we have had, and that's not just LGBT couples, it could be heterosexual couples as well. In other instances, the divorce has to be recognized in the place where both parties were domiciled or resided at the time of the divorce, even if the divorce was procedurally valid in the place it was granted. So that would be prong number one. And then USCIS has generally refused to accept a divorce if neither person was present where the divorce occurred. Let me give you an example. A couple married in Florida, prior divorce of US citizen occurred by mail. Basically had a Mexican divorce. Neither him nor his prior spouse were residents in Mexico, so there was no jurisdiction, but apparently, even though it's valid there, Florida, where we are, does not recognize that according to Florida law. So we need to make sure that those match. Their current spouse did receive their residency. The problem came about when they went for naturalization and they came to see us, and with a denial in their hands, saying we made a mistake when we granted you the permanent residency the first time because your prior divorce was not valid. So the one way around that, if you do encounter that, and that's not the only occasion that I encountered that, is an annulment. Annulment generally does fix the prior error. What you also see that happening is when couples are here on investor visas, for example, and in their country, the same-sex marriage is recognized, but then there they can get simply divorced by filing something online, then they get a certification back online. Finland is one of them, for example. Very, progressive country. You don't even need to go to the court, or you need to file anything in person in court. You don't need to appear. You file, you both sign, and it's done. It's not recognized in Florida because Florida requires at least the petitioner to appear in court. So things like that are very, very critical that we see where we are. Randall, do you see anything else?
No, I'm just surprised to hear that about Florida, because in New York, you don't have to appear in court to get divorced either.
Oh, I know. I got one of those in New York. I didn't have to appear.
The one other option you could think about if you're faced with a incomplete divorce and therefore an invalid marriage is sometimes they could just get remarried after the divorce becomes complete.
Yep.
So in New York, for example, they're happy to marry you even if you're already married somewhere else. You can just get a new marriage and proceed based on that one.
Yep.
Let me ask two follow-up questions, Connie, and Randall, just to be perfectly clear. So there are a number of countries which offer some sort of civil union or civil partnership, but they're not calling it marriage. It's not written into their laws as marriage. Would any of those, under any circumstances, qualify for immigration benefits?
If there is no marriage, there is no immigration benefit. Mm-hmm. Some countries recognize, there are some countries, Ecuador, Germany, Greenland, Hungary, Scotland, Ireland, last I checked, that offer almost identical, very similar legal rights and protections to those without marriage, but without an actual marriage. It's not the same.
Mm-hmm. Okay.
Because the legal marriage did not occur.
Gotcha. Okay. And then in the United States and some other countries, we have common law marriage. Basically, if a couple is living in a state that recognizes common law marriage, if they hold themselves out to be married, after a certain period of time, that can be actually considered to be a legal marriage. Have you seen any same-sex couples in that situation, or heard of any who have availed themselves of that aspect of the law?
Yes, California, Oklahoma comes to play. Top of my head, if a couple lives in one of those states that recognizes common law marriage and they meet the time requirement, they hold themselves as spouses and they do intend to get married, that's one of the prongs, then yes, it's recognized and it's valid for immigration purposes.
Okay.
Have you had any of those cases approved?
Yes, one in California. In Oklahoma, we have one pending.
I normally advise my clients to just get married.
Oh, I do too, but it's a little bit more complicated. One of them is military, and then they would have to disclose that. It's a little bit more complicated. LGBTQ couple are faced with so much bias. Okay, they are faced with bias at employment, at their place of abode, at their place of, and with military, even though they have don't ask, don't tell, they do ask and they do tell. Okay, so it is very difficult for couples who work in the military, work for the government or a government contractor. It is very difficult for them to get married. And in some of these cases, for example, this gentleman, it's actually military, and he is based in Oklahoma. They don't live on the base with the spouse because they cannot. And it's a lot more complicated than that. That's the reason it's still pending. So we are hoping for a positive outcome, because for all intents and purposes other than that, they do hold themselves as spouses.
Interesting. I had a related tangential case of military, but the immigrant spouse was from Saudi Arabia and from a somewhat prominent family in Saudi Arabia, so was very scared to have a same-sex marriage be any sort of public record. So what they did is they actually went to California from New York, where they have something called a confidential marriage, and it's just a slightly different procedure so that they could get married and it doesn't automatically appear in public records.
I didn't even know about such thing, a confidential marriage.
Randall, what state was that? You said?
That was in California.
California.
I didn't know about it either. They learned
very
about it.
Interesting, and probably something that people should be aware of, because I can see that that might be of interest to a number of people. Very interesting. Let's talk a little bit about proving how you have a bona fide marriage. There might be some special obstacles faced by same-sex couples. I mean, any of us who have ever practiced immigration law know that when you're taking a couple into an interview for an adjustment of status, or when they're going to the consulate, you know, it's expected that they're going to prove that they have a bona fide marriage, which is a marriage that they have entered, the parties have entered with the intent to have a family relationship of unlimited duration, right? An ongoing family relationship, and not entered into simply to gain immigration benefits. Now, couples usually prove that, as we know, by showing things such as jointly filed tax returns, or bank statements with both names on the account, or proof of insurances, proof that the parties live at the same address with a lease or a deed to a property. But there might be some specific problems and obstacles faced by same-sex couples. So I want to pose to both of our guests, how might a marriage petition packet look different, you know, for a same-sex couple? Suppose, for just to use one example, suppose they have one of the partners or both of the partners have not shared the fact that they've gotten married with their families, and so their family might be unaware of the relationship. Let's talk about how the packet might be different.
Randall?
Honestly, the package going in, I include whatever I have. I don't include what I don't have, and we see how it goes. I mean, I have my checklist of documents that I ask for. I ask for a lease. I ask for joint bank accounts, joint tax returns, etc. I don't personally, in my practice, usually submit affidavits from people, so I wouldn't be asking for family affidavits. It's more in the interview that these things come up, I think. And I tell my clients, we expect the USCIS officers to have a very 1950s view of what marriage should be, as you described. You know, they live together, they share finances, they know each other's in-laws, they're going to have children, et cetera, et cetera. None of those are absolute requirements, but anywhere where they diverge from the 1950s model or don't look like the Brady Bunch, they should be prepared to explain it. So particularly, as you noted, a lot of my clients, one or the other is not out to their family. They need to be prepared to explain why their family was not at their wedding, or why there are no pictures of them, or why they ask one that if they've met the other's parents and they say, no, I don't even know their names.
Connie?
I am a little bit, I tell them we are stuck in the 1960s, Randall, not 50s. And I really do. And I tell them that the government expects typical house with white picket fence, with the husband going to work, waving goodbye to the wife. And that is what is acceptable in their image. So it's up to us to educate the immigration officer that even though we may be different, that we are not that different after all, we are the same. So, of course, the bona fide package is the bona fide package. What they have, that's what you submit. When it comes to cohabitation is not always necessary. We have some highly educated couples. One of them could be a medical resident at some hospital. The other one could be a medical resident at another hospital 3 states away. It is what it is. You may not be cohabitating for other reasons. One of you may still be living with your parents, and parents don't even know you're married, let alone your orientation or, how you identify yourself, right? So it's not always necessary to explain, but I always tell the clients, be ready to explain in case the question comes up. Expect a request for evidence in some cases. Don't submit I don't believe in submitting anything to the document that is not absolutely necessary for them to reach a decision. I don't necessarily feel that we should give them everything, the kitchen sink, and hope something sticks. Give them to meet the burden of proof and nothing more. They can always ask for more. Some clients choose to don't file yet, wait another month or 2 months until I'm gonna have X document. We wait if that's what they want, if that is the case. That is usually the case when there is no cohabitation. For some reason, one spouse cannot list the other at the place of employment because they are afraid of repercussions or how they might be viewed or afraid of losing their job. We do not request affidavits from family members unless they are out to their family members. And we have to recognize that most people don't come out to their families until way later in life. Sometimes they don't come out at all. And you don't know how their relatives or families are going to support their identity or their marriage. So we stay clear from that. But to the practitioners who are attending this, we always are preparing an affidavit, perhaps before the interview, and have it ready just in case. It is also important that we make it in the record, either at the initial timing of the petition or at the time of the interview, that family should not be contacted. Family should not be contacted because they are not aware of the relationship. They do not support the marriage, whatever it is, because we all know if HSI sends, or the fraud detection unit or whatever, if they send somebody home, they don't care who it is. They're just going to ask, hey, do you know if this is the, Joe's husband, right? So that creates serious safety issues, right? Creates serious safety issues. Creates rife in the family or at the place of employment where the fraud investigation unit or whoever they go and ask questions, and that should not happen. So we need to make sure that in the record it is clearly stated, do not contact the family because we are not out, or his family knows but my family doesn't.
Mm-hmm. Have you encountered in real practice any instances of officer bias, and how would you address that if you thought that it was coming up? And do you know, to either of our guests, what sensitivity training, for lack of a better term, the officers are receiving these days? Is there guidance in place at the adjustment offices, at the district offices, to advise adjudication officers, what is the line that they should not cross in these type of cases?
Okay, so yes, they are supposed to treat same-sex couples the same way that they treat any other couple. They are supposed to be sensitive as to the issues that we just discussed, for example, not being out to their families, okay, or to their employer. They need to understand those things. There are certain questions that they can ask they can ask to determine the bona fide of the relationship. Some examples of inappropriate questions would be, exactly how do you identify yourself in the LGBTQ spectrum? What are your related experience to this? What is your sexual life? What's your sexual life as a couple? It's none of their business, okay? If they ask questions about their bodies, okay, and that is particularly sensitive to transgenders or cisgender individuals, okay? If the marriage was consummated, remember, marriage being consummated, it's not a requirement. However, 1950s, 1960s, right? So that is one of those things. We had in the Miami field office, we did have an officer who asked one of the partners, so when you guys are engaging in sex, is he using his right hand or left hand? It was in a way a very valid question because they wanted to know if you are ambidextrous or not. Of course, we objected, we got that struck down, but we asked them to rephrase. So then they asked it a different way, but the way it was phrased initially, it was very inappropriate, okay? So they can ask about coming out, but they have to stop if the person says, I have not. They can ask about the timing. However, they can use the timing question to determine the bona fide of the marriage. If you got divorced and then 2 weeks later you came out and then 2 weeks later you got married with same-sex individual, then we are having a problem. So they wanted to see the timeline. Now, if you were always, maybe you were, so to call it, in the closet, right? So if you were there and you haven't, but your wife kind of knew, so you were separated for the past 20 years, but you stayed married because that's what family expected you to be, right? You live in Martha's Vineyards, they expect you to look a certain way, right? So those are the things that do come up. And then the last thing that they cannot ask about, where exactly are you in the transitioning process, for example, for transgender individuals transitioning one way or another, because it's all about how they identify themselves.
Now, Connie, you made an interesting point that you had in the past requested that a case be transferred from one consular post to another consular post because you thought that there was inherent bias. Tell us about that.
Yes, so we did have a gay couple, and it was in Casablanca in Morocco, if I'm not mistaken. And the person was terrified to go to that consulate. And he was terrified because his cousin was working security there. Mm-hmm. Okay. And then later we realized that this is very widespread. People are afraid because the people who provide security, or some of the people working in those consulates and embassy, are locals. And especially in smaller cities, everybody knows each other. So they are afraid of how their safety is if their safety is at stake, if their life is in danger. So you can request a change of venue. The consulate may argue jurisdiction if the client, for example, has not lived there, or that wasn't their last place of residence. For example, we were able to move this Moroccan gentleman to France. Okay, so he had his interview in Paris. This was pre-pandemic, but that happened. You can ask the consulate that you preferred to be the venue, okay? And you must specify that it is a same-sex couple, because otherwise they will shut it down. You have to specify why you are requesting a different consulate. And be prepared to explain the threat to life, the fear of being hurt, the fear of being killed if somebody locally finds out, and especially if you're afraid for family members and so on. The NVC attorney email is no longer a thing, so you cannot communicate with NVC attorney. So all the requests have to be made with the consulate where you prefer that the interview take place. And you can also request that if the visa is going to be granted, you can request that the FOIL has only initials for the first name of the individual. So it could be, instead of Joe Smith, it can be J. Smith.
Mm-hmm. Well, let's go a little more deep. That's very good, Connie. Thank you. I want to go a little more deeply into prior heterosexual marriages, because this is something that I had seen a lot of, a very long process of, finding their place on the spectrum and so forth. So you'll encounter probably a lot of individuals who have had heterosexual marriage before they enter a same-sex marriage. Aside from you mentioned the timing aspect of it. I mean, if you get divorced from, let's say you're a man, you get divorced from a woman today, a week later you marry another man. You know, obviously, even with a heterosexual marriage, being so close in proximity in time can, you know, sort of heighten the concern by USCIS about, you know, the bona fide nature of that marriage. But aside from being very close in time, are there any other considerations or things to be aware of, just things to know or ways to prepare when you have a client who's in a same-sex marriage who has previously been married to an opposite-sex partner?
Yes. Yes, and particularly, okay, and I'm going to read this section because this comes from a practice advisory at ILRC, okay, and it is so well worded that I don't want to paraphrase it, okay? So it actually, seriously, it says opposite sex prior marriages are not evidence of the validity of the couple's current marriage. Many individuals who identify as gay, lesbian, bisexual, or queer do not come out until well into their adult life, after having been married in an opposite sex relationship and having children. Because of this, such marriages are common in the history of many individuals most of the time. Those marriages were also bona fide and not entered into for immigration purposes. Therefore, evidence in a person's history that they have not always been out should not be confused with evidence that this person committed fraud then or is committing fraud now. If this confusion arises on the part of the adjudicator, the advocate should be prepared to help clarify and to protect the client from having to respond to accusatory and improper interrogations. What I take from that is ask for a supervisor.
Always a good
Doesn't
practice.
that say it? That says it so well, right? It's like I can't.
It really does.
Paraphrase that.
I would just add to that, though, where the previous marriage was an opposite-sex marriage, and, for example, if it's a petitioner, and either the petitioner had petitioned their previous spouse or been petitioned and got permanent residence and then citizenship based on that previous spouse, I usually prepare them for questions about the validity of the previous marriage, because the combination of the first you were straight, now you're gay, and you happen to get your status through your straight marriage and now you're gay can potentially raise questions. And I think maybe even legitimate questions.
And
So,
also, yes, and also be alert that even if it was a case that had been with, you want to be aware of that and prepare for those questions.
Yeah.
All right, well, let's move on. And now talking about children born outside the United States to married couples through in vitro fertilization or surrogacy. Do either one of our guests want to talk about that scenario, special considerations as far as the children's right to gain immigration benefits?
Not anymore. Not anymore that I know of. Prior to the policy change, the children had to be genetically related to the U.S. citizen parent, and we both know the two major cases, one of the Canadian couples and the other one with the one in Italy living in France and then moving back to the United States. First, the government didn't recognize only the one that was genetically related to the US citizen parent. Now there is no distinction. And they used to treat them as an unwed parents. Now it's totally different. They are, if they are married, they are married. And that was the argument before the Supreme Court. And that was resolved. And that's no longer an issue. And those who were denied based on that prior policy, they can reapply.
All right, Randall, anything to add on that?
just thanks to Immigration Equality for litigating that.
Yeah.
Excellent, always. All right, foreign spouses in a same-sex marriage are treated the same for naturalization purposes. Essentially, whether you're a same-sex couple or an opposite-sex couple, if you are a permanent resident for 3 years and you've been married to your U.S. citizen spouse for 3 years, and the spouse has had U.S. citizenship for 3 years, you can apply for naturalization with the shortened residency period, which is a great benefit. The K-1 fiance visa is fully available to same-sex couples. It's a non-immigrant visa. It's valid for one entry. Its sole purpose is so that the beneficiary can marry the U.S. citizen petitioner within 90 days of arrival. It does require that the individuals have met in person once in the preceding 2 years, and that they manifest a genuine intention to marry, and that they are legally able to marry. Have either of our guests seen anything you want to bring out with regard to the K-1 process that might be of particular interest for same-sex couples?
The only thing that I want to bring out that has nothing to do necessarily with the same-sex couples, but with just the consulates not processing anything lately. It really is the priority of the cases. Right before the pandemic, if you guys remember, it wasn't even a point in applying for a K-3 visa because the K-1 was being processed so fast, or the immigrant visa was being processed fast enough, right? Now, there is priority given to immigrant visas in some consulates and priority given to fiance visas in other consulates. So you really need to know your consulate and what process is faster for the client. And in some cases, you might be better off doing a K-3 once they are married, which would require them to meet in a third country, especially if they are same-sex and they cannot get married in their country of birth, okay? But that may be faster because you can apply for both processes at the same time.
Mm-hmm. And
Randall?
Well, I would just add, I rarely do fiance visas because most of my clients are better off either doing an immigrant visa or traveling to the US and eventually changing their minds and doing adjustment of status. The one place where K-1s, it's same-sex couples are a place where K-1s are often useful, because if the person is in a country where they are not able to get married and they're in a country where it's not easy to travel to other countries, or they can't get a US visa to get married here, the K-1s are actually great for same-sex couples because we can get married in the US.
Yep.
Mm-hmm. Absolutely. Now, if marriage is for some reason, if marriage is not an option that they're considering, whether it's a practical reason or a personal preferences, what other options would a couple have? What would be your most common go-to options?
Well, depending on where they are and what their situation is, explore whether there's any employment-based green card route. Are they an extraordinary ability in something? Are they in a place where they can get a perm? I don't do perms, but I have friends who do, so I can refer them to them. Mm-hmm. And of course, I often explore asylum as an option,
right,
which we'll talk about later.
Yep. That's actually a pattern that I hear of through the grapevine, is people who they may have a relationship. It may or may not in the United States with an American partner. It may or may not be serious enough for them to consider getting married. But in their back of their mind, they're thinking, well, if it doesn't work out, I'm going to apply for asylum because I don't want to go back to where I'm from. This is seems to be not uncommon. You should also, I would say also, maybe look at such options as DACA. If the foreign national's been here for a long time, look at perhaps they're from a country where there's TPS. Maybe there's a U visa if they've suffered some sort of harm in the recent past. Maybe there's the option for the T visa, depending on the circumstances that they were brought in. So really go through, maybe they would be interested in student visa status if they're still in status, and if they have the means and their circumstances are such that they want to study in the US and they can study in the US, maybe you want to look at a student visa. But before then we're going to segue to asylum and start talking about asylum. But let me give Connie a chance to chime in. Anything else about other options, Connie?
T visa, U visa, SIJS if they are under the age of 21. Randall doesn't do perms. I do. I don't do asylum. Randall does. So, and that's basically where I am located. The asylum denial rates in our asylum office are quite high compared to other parts of the country. So while Randall may tell a client, move to New York because it's easier for you, for example, or move to California and then we apply for there, I might tell the client, I cannot take your case because your chances are so low that I'm not going to waste your time and money. It really depends where you are located as well.
Yeah, and practitioners, those statistics are available. You can find, whether it's on the EOIR, maybe on the EOIR website, probably is.
On the track.
Their statistics are out there so that you can see which immigration courts have the higher rates of granting asylum claims, and it's broken down by court. And advise your clients to move to a more favorable jurisdiction, perhaps. That's something.
And I have done that in the past. It used to be where traveling on TPS was accepted in certain, remember, and now it's not. So I had clients move to the 6th and the 9th circuits.
Yeah, and there are, and that comes up a lot in criminal immigration, where certain crimes are considered to be aggravated felonies or particularly classed in the federal law in some circuits, but not in other circuits. And so if the person wants to have any chance, they really have no other alternative but to have their case heard in another circuit. Let's talk about LGBT asylum claims. This is an area that I'm very interested in. I saw a fair number of these cases. You know, the standard for granting asylum, to get asylum, the person has to be inside the United States. They're outside their country of nationality or last habitual residence. And they essentially qualify as a refugee under the definition for what is a refugee. It's a person who's outside their country of nationality or last habitual residence, and they're unable or unwilling to return to or avail themselves of the protection of that country because of persecution or a well-founded fear of persecution. Here's the key: on account of one of the protected grounds, which are race, religion, nationality, membership in a particular social group, or political opinion. Okay, so that's where we get our definition of refugee. And for LGBT individuals, you know, the fact of being such an individual you would usually be looking at a social group claim, but you have to very often, you can also pull in a political opinion claim if the person has engaged in any sort of activism around their LGBT status. You might be looking at both of those depending on the legal climate in the country that they're from and what their actual activities have been. So let's talk about some of these issues. So Randall, let's open it up. I mean, how do you, let's say you have a client, hypothetical client comes in. Let's look at two different hypotheticals here. Let's look at a hypothetical of a person where the official legal climate in the country that they're coming from specifically persecutes LGBT individuals. Let's look at, you know, you get a client from a place like Uganda or a place like Iran, and they want to apply for asylum. You know, how do you approach this case? And then let's contrast that with a case, you know, someone is coming to you, let's say they're from a Central American country where there's not a law against being LGBT. However, the social climate and the maybe there are gangs, maybe there are other non-state actors who have been persecuting the individual. So let's talk about these two very common fact patterns and how you approach these cases.
So first of all, I would just to go back to what you were saying before about proceeding based on particular social group versus if there's some sort of a political opinion case. In my experience, I have never had either an asylum officer or an immigration judge question sexual orientation as a particular social group, even in the last few years when the administration was really attacking the concept of a PSG and narrowing it as much as they can. I haven't seen any pushback on that case. So I've never even briefed sexual orientation as a PSG. So on the other hand, I've had more pushback at the asylum office on political opinion cases than almost anything else. Somehow, even though that was where it all started, like political opinion is what the normal layperson thinks of as the reason for political asylum, that's what we call it. It's harder to win a political opinion case than to win an LGBT PSG case. So I've never actually, I mean, if there's some political opinion, I'll throw it in as a throwaway, but it rarely even gets to that. To your specific question about the hypotheticals, yeah, if it's on the books, then that makes it easier for the most part. You don't have to go into as much detail in country conditions. I would footnote that, though, that you need to be prepared for an officer or a judge to push back in some countries where it may be on the books but isn't enforced very often, and you need to be able to make the argument for why even an unenforced law is actually a form of persecution. I'm thinking, for example, of Singapore, where it's on the books that it's illegal to have same-sex relations, but it hasn't been enforced per se in many, many years. It's still a country where it's very socially unacceptable and subject you to persecution if you are a gay man in particular, a gender nonconforming person. So regardless of what the law says, I always submit a huge stack of country conditions evidence, starting with the State Department reports, but including Human Rights Watch, Amnesty, newspaper articles, scholarly articles, anything I can come up with to show that whether it's on the books against the law or not, this is a place where people are frequently harmed because of their sexual orientation or gender identity or HIV status or perceived any of those.
Now, there's an excellent, adding to what you're saying, there's an excellent document produced by the United Nations High Commissioner for Refugees, and it's their Guidelines on International Protection #9, which is specifically about LGBT. And they do, discuss, how you should analyze these cases in light of international human rights law as it applies to refugee and asylee claims. And they talk about, they talk here about the laws criminalizing same-sex relations and whether explicit laws criminalizing same-sex relations it's established under international human rights sort of standards that such laws are discriminatory and violate norms, and where individuals are at risk of persecution or punishment from those laws, that is sort of prima facie evidence of the persecutory character of those laws. But as Randall was saying, then you have to also consider, even rarely or seldom enforced criminal laws could, lead to an intolerable predicament for an LGBT individual, which could rise to the level of the persecution. So you have to approach these cases with, people should not have to hide who they are in order to survive or in order to live a normal life. So what impact is the non-enforced law, but the law which is still on the books, what impact is that actually having on the person's life? And start there as the starting point for your analysis of whether or not it rises to the level of persecution. So depending on the country context, such laws can create or contribute to an atmosphere of intolerance, and they can generate a threat of prosecution for such relations. In many years ago, we had such laws here in the United States. There were still sodomy laws on the books in a number of jurisdictions. And those laws provide a tool that can be used for blackmail or extortion purposes by both government authorities, police, and non-state actors. Those laws also enable political rhetoric that can expose, LGBT individuals to risks of persecution, and they hinder individuals from seeking protection from the government. So I just wanted to add that when you are considering, what constitutes a well-founded fear of persecution, you need to really get into the facts of both the individual circumstances and the legal environment in the country and the region that you're operating in. Now, to our guest, the issue of relocation, I've often wondered about. Have you seen this come up? There are countries, I can think of a lot of countries where there might even be same-sex marriage available in the capital city, but in outlying areas in the provinces or in other locations, the situation's totally different, and you have a very sort of difficult environment to be LGBT. I'm thinking of Mexico for one example. So have you had the issue of whether the person can relocate? Has that come up, or how would you how do you analyze that aspect of it? Because that might be an argument that that ICE makes in trying to deny your client asylum.
Sure. Yeah, it's absolutely an issue, and it's an issue that I raise with all of my clients. If internal relocation is a reasonable option, then that's a grounds for denying asylum. I think Mexico is a difficult country. I don't think I've had just a sex orientation case from Mexico. I've had transgender people win cases from Mexico, because Mexico City, Puerto Vallarta are pretty safe places to live. Although I would certainly not make that argument if my client were a gay person from Mexico. I have a lot of clients from Brazil where the sort of the reputation is that both Sao Paulo and Rio de Janeiro are very gay-friendly, safe places. Rio has Carnival, Sao Paulo has the world's largest gay pride, and I believe there even is gay marriage in some parts of Brazil now. But there is also a huge amount of violence against LGBT people everywhere, including Rio and Sao Paulo. So again, what I do is just give them as much country conditions evidence as I can. In the Brazilian case, I used to always submit an expert affidavit from a professor who specialized in LGBT persecution in Brazil, who wrote 150 pages about how dangerous it is. Since the election of Jair Bolsonaro, I've stopped bothering with that because the federal government has become so openly homophobic. But in other countries where maybe the federal government is not, or the national government is not as homophobic, and it appears to be a safe place for LGBTQ people, it can often be helpful to have, in addition to published country conditions, to have a specific expert opinion who can say, I read the affidavit of the client and I know this country and I believe that she would be at risk living there.
Now, sexual orientation can be either, the person's actual sexual orientation, or it can actually be perceived sexual orientation. So you may find clients, depending on where they're coming from, they may have encountered persecution, but they still may be very uncomfortable identifying themselves as an LGBT person. So, you have to sort of don't fall into the trap of expecting the person to fit neatly into any preconceived sort of way of being. They may not yet be out. They may have concerns during the asylum process about privacy. Let's talk about the concerns about privacy in the asylum process. Randall, have you encountered clients who are concerned that by applying for asylum, they may have to discuss aspects of their lives that they're uncomfortable with, or have the clients that you see mostly been pretty much more or less comfortable with themselves?
Sorry, I thought you were going somewhere else with the privacy question. Yeah, absolutely. I mean, many of my clients and many LGBTQ asylum seekers, and not asylum seekers in general, have suffered serious trauma in the past and are still suffering from post-traumatic stress. And the way they deal with that is by, one of the very common coping mechanisms is not to talk about it to anyone. So I often will refer clients who've suffered serious trauma and are having trouble talking about it to a mental health professional to help them just with the idea of going to a government official and talking to that government official about their sexual orientation, something that in their home country, their family or their teachers or the general public or the government has persecuted them for.
Where did you think I was going with the question? Now I'm curious.
Well, the privacy question, I thought maybe you were going to be wondering about people's worries that what they tell to the asylum officer will somehow get out to their family or to their
let's talk about that. What do you say if a client voices that concern?
I tell them that even though I don't trust the US government in general with most things, I actually do trust that the asylum system is good at keeping confidentiality, and that it's taken very seriously within the asylum office and within the immigration courts, that the information you're shared in your asylum application cannot be shared outside of the office and cannot even be shared within the US government except on a need to know basis.
And I used to tell them that all the time. And on an unrelated, and it was not a same-sex marriage case, it was a VAWA case, the government released to the other party, okay? Because the other party did a FOIA on the regular I-130, the entire file was released. You know, like usually they redact almost everything and you can't get anything. This one, they got all the good stuff. So they released the entire VAWA claim. So I tell them it's so siloed, you're not going to see it. Even the officer, when you go to the interview, they really don't see your underlying basis. They're not going to ask you questions about it. It does happen. And I tell them, as much as I'd like to believe that it's foolproof, I don't think it's necessarily 100% secure. Like nothing ever is. There could always be a ransomware, a hacking, could always be that case. But generally speaking, that it's safe.
Yeah. And if you're getting asylum, you're not going back to your home country for a very long time anyway. So if the information gets out there, the point is we're protecting you from having to go back there.
That's right. Now let's talk about the Real ID Act added something to the asylum law where it said that the characteristic had to be a central reason for the persecution. So if the person was persecuted, you have to show that the characteristic that they are claiming as the reason for the persecution was the central reason for their persecution. This was something that was sharpened and made a little more difficult in 2005. You can encounter people who were persecuted, but they're going to have to demonstrate that it was in fact their sexual orientation or perceived sexual orientation or gender identity that was the central reason for that persecution. It's just something to be aware of, that the standard was raised a little bit by the Real ID Act. Let me mention the problem of have either of our guests encountered any difficulty with the detention facilities or detention settings? You know, the removal proceedings are civil proceedings, and yet the government has the ability to detain people for all intents and purposes, incarcerate them as part of these proceedings. There are special considerations for LGBT individuals in any detention facility. Things to watch out for would be that if the individual voices a concern that they might be victimized in the detention facility, the government may respond by putting them in solitary, essentially, which would make their stay even more difficult than it already is. In particular, for transgendered individuals, they are much more likely than non-transgender individuals to suffer from violence in any detention setting, both at the hands of the other incarcerated inmates, as well as potentially from the staff, or encounter hostility from the staff. To either of our guests, anything that you want to add about special concerns for detained settings, detained cases?
I don't do detained cases. I cannot speak to that. So
okay.
Yeah, I actually don't do detained cases either.
Okay.
I mean, I can just add, I guess, that the other difficulty that I know of from colleagues in preparing a detained case, is it's very difficult to get access to the clients, to the applicants. And in particular, when you're trying to prepare a very complicated case about persecution, and with LGBTQ people, it's often persecution by people very close to them. They're really difficult conversations to have. And I have many, many, many meetings over a period of months preparing for an asylum interview, and even just preparing the affidavit. And that's just not possible with a detained client. So you need to find a way in an hour without good privacy to get information that it normally takes me weeks or months to get.
We had a client in detention, and thankfully, because of COVID, he took voluntary departure at some point, but we were debating whether we are going to do asylum, some sort of hardship. We were going to do VAWA. He was married to a US citizen, but because of other reasons, he was in detention. And it is impossible to bring the psychologist there to do an evaluation. And we were lucky. We have a psychologist that worked very closely with us over a period of weeks. The spouse was willing to forego their time meeting with the client so that the psychologist could use the time to go and try to remember everything, because you're not allowed writing instruments, you are not allowed recording instruments. It is just almost impossible to prepare anything that requires a declaration, really, in detained cases, and particularly where it takes months. It's not a simple, let's fill out this application, we'll file something later. This is a case that needs to be developed.
Now, there are a number of immigration organizations across the country that have a focus on detained cases and do excellent work in trying to provide support or litigate detained cases. And there are a few of them that have devoted some of their attention to specific LGBT concerns in the detained setting. And I just want to mention that I will be posting a blog post on the LGBT issues, both taken from what we've discussed today and developing some of these points farther. And I'll make an effort to include the names of some of those organizations so that people have that as a resource. I think that if you're doing detained cases, you should really be familiar with some of the organizations that are litigating in the detained settings and have those in your Rolodex, because circumstances can arise when you really need support from colleagues who have been successful in challenging the administrations in some of these facilities if your client gets into a dangerous spot in the facility. Let me move on in our remaining time to some of the transgender specific issues. I want to, transgender individuals have some very specific concerns. Their situation is going to be different from others, and I think if you're working a lot with transgender individuals, you should also familiarize yourself with organizations and resources that can support some of the other problems besides the immigration problem, some of the other issues that they may face. Transgendered individuals suffer a lot of employment discrimination and housing discrimination. And particularly if you're talking about undocumented individuals, if they are transgender, their chance of having problems with their employment or difficulty with their housing is going to be markedly greater. If you're working with those individuals to really familiarize yourself with other resources that can assist them in the event that problems arise with their housing or their employment. So let me mention that according to the Williams Institute at UCLA, there may be approximately somewhere in the area of 267,000 LGBT adult undocumented individuals in the United States. And perhaps of those, 15,000 to 50,000 of those may be transgender. That's extrapolated based on the best estimates we have for the percentage of individuals in the general population who are transgender. Many transgendered individuals came to the United States to escape severe and often life-threatening persecution because of who they are. Some of those came fleeing poverty, but were compounded by gender-based discrimination. Others were taken to the United States at a young age, the same as non-transgender individuals. Workplace discrimination combined with undocumented status results in a very high incidence of discrimination and having relatively few options for employment. The result of that is that there are a number of people in that circumstance who resort to involvement in informal economies, in some cases illegal work like sex work, in order to survive. Also, the partners of children and undocumented trans individuals may face discrimination at higher rates than the general population. Individuals who are undocumented who are also transgender may have an overwhelming fear of being outed at their work for both their, number one, for their transgendered status, and number two, for their undocumented immigration status. So I want to turn it over to our guest to talk about gender markers. This is something we talked about concerning, what specific considerations do you have for when gender is listed as an identifying characteristic on identity documents? Either of our guests?
Yeah, so particularly, to give an example, we had an individual who arrived here on a tourist visa as a male and applied for asylum, eventually got married. Asylum was eventually terminated. And the problem is throughout this process, this individual had work permit as a male. Then right before marriage, the individual transitioned. There is, by the way, surgical treatment is not necessary to show that someone is transgender. It is really about how the individual identifies themselves. It's a broader range of actions, and to see that and how that applies on various state laws, because each law would require a different thing in order to acknowledge the gender change, okay, if they are here in the United States. There is a very good policy memorandum from 2012 that addresses adjudication of immigration benefits for transgenders individual and changes the field manual. So, for example, this particular individual is from South Africa. It takes 6 years in South Africa to get a birth certificate or another document that would show that his name changed or his gender changed, and of course both changed. And without the birth certificate cannot change the passport, and then obtained residency, and the residency is inconsistent with the passport. So that creates issues, and then we advise them, don't travel because you are going to have issues coming back, even if you travel with all the documents, the letter from the physician, everything else that you need, you are still going to have issues traveling back. And the problem is they can't not finish the birth certificate in their country unless they travel back. Well, right now, because of COVID, they just can't. But those are the issues that individuals are having to go through. And it really depends on where they are located in the United States, what the state law is in their particular state of residence, what is required by their regular DMV, for example, to apply for an ID with a different gender than the rest of your documents. Does that match your identity documents that you had before, right? Luckily, this individual had work permits with the same alien number and all the same identifying information under both names. Okay, so under both names and both genders, the older ones as a male and then transitioned. So serious considerations, and it's affecting them. They cannot travel. They have to wait until they become citizens so they can get the US passport that says otherwise. It is just a nightmare. I mean, I do advise even heterosexual couples, do not change your name at all. Please don't change your name until after you become a citizen, okay? Unless you really like secondary inspection a lot. So I really do tell them not to, and it's particularly serious for transgender individuals. So changing the gender markers on documents, changing the names on the documents, it's a nightmare. It's a nightmare for them. It's costly, and it takes years in some cases.
Well, or never, like, as you noted, you can get, usually within, if you're going through a process, you can get the correct gender on your green card and on your US documents, but some countries will never change your birth certificate. I'm thinking of the Philippines. There's a lot of cases of Filipino transgender people who they always have a passport with the wrong gender, essentially.
Yeah.
And it may not cause, they may go to secondary when they get back to the US, but they'll eventually get back in.
Yeah.
But going to other countries, they may not be able to get in.
Yeah.
Right? It may not be so easy.
And I want to point our listeners to an excellent resource on the transgender issue. There was a report called Our Moment for Reform, which was produced by the National Center for Transgender Equality. And that listed a number of excellent considerations for further reform, things that, if you haven't really looked into these issues, you might not even think about. For example, E-Verify, the employment eligibility verification system, recommending or advocating that only necessary personal information should be included, information that is actually necessary to verify employment eligibility, including additional information, gender markers such as gender in the verification system will cause any gender discrepancies in the person's documents to be flagged as suspicious, which could potentially out certain transgender employees. I'm going to cite, I will cite, and I recommend that you take a look at that report as well, National Center for Transgender Equality. To our guests, it's been a great discussion, and we're running out of time, so we're going to have to wind it up. But I want to thank everyone very much again for participating, and to our attendees, thank you very much. There will be a video of today's presentation posted on the Docketwise website, and I hope that you'll join us for our next webinar next month, which will be on running a humanitarian immigration practice. Again, thanks very much to our guest, Randall Chamberlain, practices in New York City, and Connie Kaplan in Fort Lauderdale, Florida. Yes, thank you very much for participating.
Thanks for having me.
Thank you.